We'll go ahead and get started here. Thank you for joining us today for what I think will be an interesting and timely discussion of voting rights. I am Consovoy, today's moderator. As I mentioned, today's panel is about voting rights in 2017. As with the change of any administration, you will see a change in point of view on various legal topics. I think it's fair to say that voting rights may be one where we see one of the biggest departures from the prior administration to this administration. We've seen some movement already. I think we would reasonably expect to see more. And that creates an interesting dynamic, not only with respect to litigation, but with respect to congressional oversight. Voting rights is an area where Congress has shown a lot of interest. Congress has extensive oversight authority in this area. And the dynamic between the new administration and the oversight committees, I think, is a really important topic, and I'm glad that is a subject of today's conversation. With that, I will introduce our four speakers and turn the microphone over to them. Our first speaker today is Robert Popper. Bob is a graduate of the University of Pennsylvania and Northwestern University School of Law. In 2013, Bob joined Judicial Watch as a senior attorney and director of Judicial Watch's Election Integrity Project. Before that, Bob worked in the Civil Rights Division of the Department of Justice for 8 years, 5 as deputy chief of the voting section. Before that, he worked as a private attorney in New York for 17 years with a practice that covered a wide array of legal issues, including voting rights. Among Bob's many notable professional accomplishments, he developed a legal standard relating to gerrymandering that is widely cited by experts and was adopted by the Arizona Independent Redistricting Commission. Our second speaker today is Adam Ambrogi. Adam is the director of the elections program at Democracy Fund Voice, a nonpartisan advocacy organization established in 2014. Before that, Adam worked as chief counsel for the U.S. Senate Committee on Rules and Administration, addressing a wide range of issues related to election law, campaign finance, and other legal matters. Adam was the lead staffer for the Rules Committee on passage of the Military and Overseas Voter Empowerment Act, the Disclose Act, as well, and led the committee's legal team in examining Senate rule changes related to the filibuster. Before his work on the Rules Committee, Adam served as Special Assistant and Counsel for Commissioner Ray Martinez of the U.S. Assistance Election Commission, the EAC. And he has a range of experience beyond that. He received his Bachelor of Arts in Government with high distinction from the University of Virginia and was editor-in-chief of the Texas Journal of Civil Liberties at University of Texas Austin Law School. Our third speaker today will be Bob Sensenbrenner. Bob serves as General Counsel on the Committee of House Administration under Chairman Greg Harper. Bob serves as the committee's parliamentarian and lead legislative counsel, conducts oversight and investigations on federal election contests, oversees the Federal Election Commission, the Election Assistance Commission, and has many other duties. Before law school, Bob served as confidential assistant to the Deputy Undersecretary of Commerce for Intellectual Property and worked in the Trademark Office. He's a graduate of the Stanford Law School, where he served as editor-in-chief of the Stanford Journal of Law, Business, and Finance. Finally, our fourth speaker will be John Tanner. Mr. Tanner began his voting rights work in the 1960s as a teenager in Birmingham, Alabama, working with the Southern Christian Leadership Conference, helping to register black voters. After serving in the military and completing law school, Mr. Tanner began a distinguished career as a government attorney. Of particular relevance to today's program, Mr. Tanner litigated voting cases at DOJ for 19 years. He also worked for the Senate Judiciary Committee, in the DOJ Office of Legislative Affairs, as Special Litigation Counsel for Minority Language Enforcement in the DOJ voting section, and ultimately became chief of that section. He retired from federal service in 2009, and since then has had a solo voting rights practice representing minority voters primarily in Alabama and Texas. With that, I'll turn it over to Bob.
Good morning. My name is Robert Popper. I work at Judicial Watch, and prior to that I worked for 8 years at the Department of Justice, in the voting section of the Civil Rights Division. And I'd like to talk today about one particular item. I interpreted my charge as advice I would give to the administration. And the statute I would prefer that the administration enforce is called the National Voter Registration Act. I'd like to talk today about how this statute has not only not been enforced by the prior administration, but about how it was actively damaged by that administration. My simple advice for the Trump administration would be to start enforcing that statute, or at least to stop attacking it. Section 8 of the NVRA is the provision in federal law that concerns list maintenance. And list maintenance is simply removing voters who have moved out of state or who have died. And voter rolls are constantly becoming clogged with invalid registrations. Federal law requires that they do something about it. States hate to do this. It costs money, it takes time and effort, and they often need prompting in the form of lawsuits. Now, our own research at Judicial Watch indicates that out of about 3,000 counties in the United States, 300 have more registered voters than citizens of voting age. That can happen for a variety of reasons. Registration rates can increase, but typically that indicates a problem. And every year, I would add, there's a couple of counties that have more registered voters than total population, including non-citizens and infant children. What the voting section has been doing about this is worse than nothing. To begin with, they're doing nothing, or they've done nothing. In 2009, the Deputy Assistant Attorney General over voting informed a meeting of voting section staff that the management of the voting section did not care, her words, about Section 8 of the NVRA. This became a locally famous meeting, famous in a Washington way, meaning the Inspector General investigated this remark because enforcement agents should not be deciding which statutes they do or don't like. Regardless of this investigation, the administration under Obama was true to its word. No cases were brought in the past 8 years. No cases have been brought since I brought the last one on behalf of the federal government in 2007. During the Bush administration, there were 5 such lawsuits. There are none now. These suits are now being brought on behalf of private plaintiffs by Judicial Watch and also by the American Civil Rights Union. But that's it. They're expensive cases. They should be pursued by the voting section. Worse than doing nothing, the voting section is litigating to pare back the NVRA. And if you think about it, this is remarkable. A federal agency making war on one of the statutes it is charged to enforce. I can give you 2 examples of this, very recent examples. The first concerns Florida, where there was a lawsuit in which private plaintiffs and the United States argued that the 90-day freeze period of the NVRA applies to non-citizens. Now, the freeze period is a very logical 90-day period. It's very logical in the statute. In that period, you cannot remove individuals who are suspected of having moved to other states. It's just too near to the election. You can do that the rest of the year, the rest of the election cycle. Well, the argument was that this applied to non-citizens as well. Now, they were never eligible to vote if they're non-citizens. Both district courts rejected this, but a 2-to-1 panel of the 11th Circuit accepted it, and Governor Scott declined to pursue the appeal. So it is now the law in the 11th Circuit that in the 90 days prior to an election, non-citizens cannot be removed from the voter rolls. You should ask yourselves, as I have asked myself, why does one pursue that remedy? All I can come up with is that whoever pursues that remedy does not want non-citizens removed from the voter rolls in the 90 days prior to an election, because that's what the ruling was. Again, attacking and paring back the NVRA's protections. The second example I can give is a couple of cases out of Ohio and Georgia, in which the United States joined with plaintiffs, with amicus support, in arguing that states can't use the fact that someone has no voter activity for 2 years in Ohio and 3 years in Georgia, can't use that fact as a basis for sending someone a notice inquiring as to whether they still reside in the state. That would contradict or contravene the NVRA's restriction on removing people simply for failing to vote. 2 district courts rejected this, but 2-1, the Sixth Circuit Court of Appeals reversed. Both cases are on appeal. But again, this is an instance where the Department of Justice's voting section is attacking a statute it doesn't like, using what I would consider forward partisan arguments to parrot back. If the Trump administration does not enforce the NVRA, it should stop attacking it. I have faith it will do both. The last point I would make, and I fear I'm over time, but the last point I would make is simply this. There is a separate debate about voter ID laws, state voter ID laws, and I'm a big fan of state voter ID laws. I think they're constitutional, they're commonsensical. But just know that if we stray into that territory, that's a different topic. The NVRA is a federally enacted statute. Congress already weighed the pros and cons and decided it was going to enact this bill. The Department of Justice should not be in the business of picking statutes it likes and enforcing those, and then taking statutes it doesn't like and attacking them. That would be my point to you today. Thank you.
Thanks, Bob. Adam?
Great, thanks for having me here. I appreciate the invite from the Federalist Society. There was an interest in someone that had experience on the Senate side, and I think perhaps had a background working for the current minority to come in the panel, and so here I am, and I'm happy to be here on this panel to talk about these issues. You're all lawyers or law students, and so you'll understand the caveat that I have to say I do not represent the views of my former bosses while I am up on this panel from my time on the Rules Committee. So, my interest here is trying to think through how we frame a progress in this space, right? I mean, you're talking about voting, you're talking about voting policy and litigation. It's inherently fraught with the politics underlying it, the law and the legal debates that parties have associating with it. My question is, how do we get back to a place where we can focus on what works and what both sides can agree on? I think that we saw a very good example of how this can work and work in the right way after the 2012 elections, when there were long lines in jurisdictions blue, purple, and red, and folks that were very frustrated, including, quite frankly, a number of DC conservatives that I'm friends with were really ticked off about the problems related to voting and voting in person. And so we saw sort of a bipartisan concern related to this process, and so the then president solicited his attorney, Bob Bauer, and Governor Romney's attorney, Ben Ginsberg, and pulled them together with a group of election administrators and business leaders to see what they could figure out on how you could come across a bipartisan mechanism of solving the problem. And so the commission worked together for about a year or so. It had about 5 or 6 public hearings, solicited requests from academics across the political spectrum, and eventually came out with a series of about 17 to 19 major recommendations that were unanimous across the board. And so, and this is something that, election administrators that are on the right and the left, as well as obviously the famous, sort of legal adversaries of Bob Bauer and Ben Ginsberg, found a way to agree on a series of items. And these items include improving how we do registration in the United States, and a strong recommendation that we think about online voter registration as a way that's easy and doesn't have an impact across the board. Think about list matching in a meaningful way, because there is an issue with dead wood on the rolls. And there have been solutions recently. The Pew Charitable Trust's ERIC system provides both access and integrity, and allows states that opt into this system to be able to check and make sure that people aren't registered to vote in both states, as well as reach out to folks and make sure eligible folks are on the rolls. Sad to say, yesterday there was some news on that. The Florida Senate did not include the $75,000 that it would have cost to get Florida into ERIC. And obviously, when you get a big state like Florida into ERIC, you increase the amount of list matching possibilities between Florida and New York, and Florida and other states, because a lot of people like to move to Florida and previously had registration in those spots. They also said that we should be thoughtful about the amount of time folks have to wait in line. And, you know, I know that, you know, this is something that at times progressives really cry about and think that it's problematic. I've done a lot of election protection in a lot of different parts in this country. And let me tell you, in parts of West Virginia and parts of Florida and Ohio that are deep red areas, there are senior citizens with walkers that are waiting in line for a long time to vote, and I've seen numerous folks leave those lines. The reason we don't hear about it, there's not press in those places. It's not a city. It's not a focus. We don't hear about it. There is a problem with that media ecosystem, and so the line issue is an issue that's bipartisan. And so, what does that mean? It means that local election administrators need the resources and skills, knowledge to be able to fix these problems when they emerge. And so, the commission put together a series of recommendations that would attempt to promote more resources for local government to run elections better, to figure out how to allocate machines and poll workers in the right way, and to reduce the amount of line wait times that folks have. And so I think that the other major recommendations involve trying to improve access to military and overseas voters, Section 203 litigation, which, as I understand, was one of the major areas of litigation, proactive litigation, during the George W. Bush administration and the voting section. They had a good record of leading on promoting 203 language access cases. You know, and then trying to figure out how do you vote in a way that people live nowadays? People are busy, people are traveling for work, you know, families are running in between baseball and music classes. You know, how do you have absentee voting in a way that works for folks? How do you have early voting in a way that works for folks, that's reasonable for the election officials, but also allows working men and women to be able to get in and cast their ballot? So those recommendations were produced, got pretty rave reviews, both on the policy and the practice angles. You know, and I have a sort of a check-in report that we did last year on the progress related to this effort. I think it's something that we really need to consider in this polarized time. You have a series of recommendations that are supported by both sides. The last major recommendation I'll raise is where the commission said that there were problems on the horizon, and that's the failure of the voting machines in the future. The voting machine market is a really tough market to be into. And even though you have vendors that are working really hard to try to think through how they provide good services for a reasonable cost for local governments, because this is an inherently government, you know, function, and so they got to sell to local governments, the money just hasn't been there. And so when we think about local election officials' ability to push back against potential intrusion into the system, potential hacks or threats of hacking, how do you make sure that we actually have voting systems that work, that support the voters, make it easier to cast ballots, and are defendable against potential external intrusions? And so I think that there are a lot of opportunities where folks can work together on this, and I would encourage folks to really think about those areas that have been sort of blessed in that area. I will make one sort of last note. You know, we have worked hard, as was mentioned in my my announcement. I am a former employee of the Election Assistance Commission. It was created after Bush v. Gore to try to provide aid and assistance to local governments and to states on how to better run elections, use data, and convene each other. And there's been some controversy related to EAC over the last couple of years. In our view, both with the data that they provide, the convening function that they have, and the recent increase in support that they've had amongst local election officials, the counties, the National Association of Counties recently issued a statement of support of them. Some of the folks that had been in opposition to the EAC in the past have said, I actually think that they do good work. There's a place for a very small federal agency that thinks about things that secretaries don't have the budget and time for, as far as testing and certification, as far as being able to be folks focused on election administration, but a liaison to other areas of the federal government that deal with elections, such as DHS. And we saw this example in the run-up to last election when DHS came in and said, we're going to make some serious and significant pronouncements before the election on security of voting. And the EAC, together with NAS, both being very concerned about what this would do to their constituency, the election officials, stepped in and worked really hard to sort of pull DHS back to explain to them the process, to say, listen, you don't want to be doing this right before the election. You're not going to be able to make any changes at this point anyways. Let's get through the election and see where we go from there. So the EAC does serve a really useful liaison function to folks like DHS. Department of Defense has the Federal Voting Assistance Program that works on outreach to military and overseas voters. The EAC has collaborated with them frequently. And so it's something that we think is important moving forward and should be maintained as a very small but meaningful federal agency with almost no regulatory authority, but the ability to convene and do research and share information. You know, the last note that I'll leave on is, you know, I do think, you know, today is the 60th anniversary of Martin Luther King's Give Us the Ballot speech in 1957. And, you know, I do think, you know, he framed the concerns that he had this time about the access to the vote as not something that was seen as a de jure legal restriction. I mean, under the Constitution, everyone had the equal right, in theory, to cast a ballot. But there were systems and local structures set up that really provided some limitations and made it very difficult intentionally for communities of color to cast a ballot. And I do think that it's something, you know, it's something that we all should be aware of as we're both thinking about all the varied constituencies in the United States that vote. There is a greater concern amongst communities of color, and we have polling that shows this, that they feel like they will be facing intimidation when they show up to the polls. And I think it's something that's, it's something we all have to be mindful of. And so I look forward to questions in the future, and I have a couple extra copies of this that we brought with us if folks want to take a look at it after we're all done here. Thank you.
Bob?
Hi, thank you. I guess as a congressional staffer, I'll add in the views that I express are my own and don't necessarily reflect the views of my boss. But I thought I'd take a couple of moments to kind of discuss some of the structural differences and structural problems, and maybe present that it may not be a bad thing that Congress isn't passing all sorts of laws that relating to voting right now. You know, I think Adam mentioned, and I'll actually agree with him, that there's, you know, broad bipartisan concern about certain issues like long lines. The problem is that even if there's bipartisan concerns or consensus about this, there isn't necessarily the same agreement as a policy prescription. I mean, Congress could pass a law tomorrow that said there shall not be long lines for voting anywhere. But when you end up with litigation and when you end up with states implementing this, because inherently the Constitution vests the authority to run elections in the state unless Congress overrides it, then you have problems coming forth from that. You know, when a law passes Congress, one of the questions is Congress's oversight of this important sector coherent and meaningful? I think there should be a recognition that the Constitution designed Congress to be much more diffuse. The executive authority is vested in the president. It's a unitary thing. So when legislation comes through Congress, it represents all sorts of different viewpoints and necessarily represents legislative compromises. And when you see kind of, as you have seen, a growing tension between, usually it's one party in Congress and the president, not the party not of the president in Congress, you see a lot more difficulty in creating legislation. Bob Popper touched on some of the DOJ's neglect with respect to Section 8 of the National Voter Registration Act, motor voter. There are also other sections that DOJ was vigorously enforcing. But, if you're a member of Congress, you have to consider not only do I think this is the right policy and do I think that this is, the right thing, but do I trust the compromises to be carried out in the future? And therein lies one of the great difficulties that you're seeing. relationship between House Republicans and President Obama, I don't know that it could have been worse. There were multiple times when the administration engaged in malicious compliance, or there were multiple times which does not really have a long history in this country, where the House as a body voted to sue the president. But it evidences a distrust between the Congress and the executive branch that makes it difficulty to coalesce around principles for legislation. I guess the other tension that exists is because it's inherently a state function, you have to ask yourself of what is the role of the federal government. One of the things that the Bauer-Ginsburg Commission talked about was vote centers. And, I believe in, the Arizona primary was very famous that Bernie thought that he was, Senator Sanders thought that he was, being unfairly disenfranchised. The Arizona Secretary of State had implemented vote centers there, and it was something that had been recommended to the Bauer-Ginsburg Commission. But the implementation is terribly difficult. And, that again goes to an important part, which I think that members of Congress are becoming more and more sensitive to, of clarity in the law and regulation of, Adam worked on the MOVE Act, which has mostly been a resounding success. But part of it involved, there was a very rough election cycle where DOJ ended up suing, I think it was 8 to 10 states. And, the clarity that states need to know to comply when Congress does actually use its constitutional powers to override it is very important. When you have so much litigation and differing levels of taking care that law is effectuated, you have a lot less clarity in what the laws mean. To Bob's point of there's an open question of now, what does the 90-day period mean? Of what does it apply to? And that also creates, difficulty in Congress, because Congress, it's very difficult to explain to a member, I'll say personally, that you have to pass a law to say it means what you said in the past. But kind of those are the structural points I want to point out, and
Great. Thank you so much, Bob.
John?
Thank you. I appreciate the invitation to be here and speak to y'all and those who may watch this. Those who may watch this will wonder why I'm wearing seersucker, and it's not even Memorial Day. The reason is it's 93 degrees outside today, and I should have remembered to turn this off. I apologize. I'd like to speak briefly about oversight and the Voting Rights Act in the coming administration. I've had a lot of experience with voting rights, with oversight mainly as defense, working in the Department's Office of Legislative Affairs, and working with the White House Counsel's Office, and as the chief of the voting section and as an attorney in the voting section for many, many years. It's my observation and my expectation that there will be no oversight of the Trump administration voting rights activity as long as the Republican Party controls both houses of Congress, because the main purpose of oversight, or the most frequent purpose of oversight, I should say, is to embarrass the administration and gin up your people and the people in your party and help the advocacy groups on your side raise money. So if the Democrats were to take control of either house of Congress in the next elections, there'd be very vigorous oversight of the administration's enforcement of voting rights. But until then, I would not expect a lot unless there's something really goes off the rails, which is possible. The new administration actually is well positioned to respond to vigorous oversight of the Voting Rights Act enforcement. And that's really all that Congress and the general public would be interested in. That's the sexy issue. The NVRA, important as it is, doesn't get people marching in the streets like the Voting Rights Act does. And this administration is well positioned in large part because the last administration did less than any other administration in history on a per year basis in bringing new suits under the Voting Rights Act. During the other 8-year administrations, the Reagan administration, the Clinton administration, and now the the Bush administration, the voting section brought about 43 to 45 cases during the 8-year period. It's an average of over 5 cases a year. The 5 has been the long-term average of new Voting Rights Act cases brought by the federal government. During the Obama administration, instead of 43 to 45, it was 12, which is an amazing decline. Adam mentioned the Section 203 enforcement, the minority language enforcement. It dropped from 28 over the 8-year period to 7 during the Obama administration. So really all the Trump administration has to do, all Attorney General Sessions has to do is fire up the voting section to start bringing some lawsuits, as they traditionally have, and as attorneys in the voting section typically want to do. There are lots of opportunities. There's still many Section 203 cases and minority language cases out there that could be brought and that should have been brought already. And there's a pretty simple, straightforward template for bringing those lawsuits. There are still some traditional Section 2 Voting Rights Act cases. That's where the minority, racial minority, does not have its fair share of seats in the city council, county commission, state legislature. Those can be a little tricky because we're towards the end of the census, and I recall years ago identifying some great targets towards the end of the census and found that by the minority population had increased so much over the course of 10 years that the minority community was fairly represented or had taken over the whole thing. But much of the voting rights activity now is focused on other areas of general access to voting rights. And there are opportunities there. The private plaintiffs just brought a very successful lawsuit in North Carolina that, among other things, addressed the fact that North Carolina reduced the number of days for early voting in the state. And there are very strong findings of fact in there. Well, North Carolina reduced theirs, but there are other states, New York, for example, that don't have any early voting. And early voting is very important for the reasons that Adam was talking about, and Bob too, for making voting a practical opportunity for more people. The early voting does take longer than regular voting because if you go to a voting center, they have to figure out which of hundreds or thousands of different ballot styles you get. And that's the main reason for, or one important reason for the long lines at early voting centers. There are opportunities to minimize that wait. In Texas, of all states, if you have your driver's license, they can just swipe it and your ballot style will come up automatically. And that saves a lot of time and waiting. And there are ways to get the driver's license and non-driver's IDs out to more people than currently have access to them, although there is wide access. And so that's getting into things that Congress should be doing, changes to the number of registered voters there can be in a voting place, put a cap on that, as some states do. To do reforms with people's driver's licenses and other ways so you can move through the process faster. And I think that there are also things that Congress could do or the individual states could do to meet the two important things about the voting process. One of those, and I think everyone should be able to agree to this, that everyone who is eligible should be able to vote, cast a ballot without inordinate trouble. And the other is the people who are not eligible to vote should not be able to vote. People who, and no one should be able to vote more than once in an election. Those are pretty simple things, but it's really up to Congress to address them. In terms of the oversight of voting, I don't, as I said earlier, I don't expect a lot of oversight of the Trump administration's performance. I do think that Attorney General Sessions has a real opportunity to light a fire under a group of people who have not been producing for the past 8 years, and he will, if he does, successfully, and if they have leadership in the Civil Rights Division in the voting section, who will vigorously enforce all of the laws, all parts of the NVRA and the other laws that the section is responsible for enforcing. They'll have at least a good story to tell, and it will be easy for them to look better than the last administration. Thank you.
Thank you, John. Before we open up for questions, I thought I might offer the panelists a chance to respond to some of the comments they heard from their co-panelists. So, anybody probably want to?
Yeah, I don't have a coherent theme to the notes that I took, so this will come across as disjointed because it's disjointed. But you know, with respect to North Carolina, there was a victory in the voter ID case. Cert was denied this past Monday. However, I don't think that covers the litigants in glory exactly because of how it transpired. There was a long tangled history in which the first argument was that the effect of North Carolina's laws was to suppress the vote, but this turned out not to be the case as minority registration went up in election after election. This then became an intent case, which is problematic because North Carolina used to be required by the law to consider the racial intent of its statutes. This was teed up for certiorari, but the administration changed in North Carolina. Democrat came in and decided not to pursue the case. And by the way, the Democrats' Attorney General, I believe, is the son of one of the lawyers representing the plaintiffs. There was an emergency request by the legislature. Could they represent the defendants? And the Supreme Court said, and I quote, "Given the blizzard of filings over who is and who is not authorized to seek review in this court under North Carolina law, it is important to recall our frequent admonition that the denial of a writ of certiorari imports no expression of opinion upon the merits of the case." I wouldn't take that as a friendly expression on the merits if I were litigating as a plaintiff, and so these issues will come up again. The other point I'd make about early voting is that there are some haywire findings on early voting to the extent that the social science may be that it suppresses voting for reasons no one understands. You know, may have to do with human nature and simply putting things off that you should do today and you end up never doing them. They don't know, but Barry Burden and the people who represent plaintiffs as experts in these cases have written a paper saying that early voting may lead to lower voting, lower turnout. They're not sure why. You know, and I guess the last thing I would say is that, you know, if we're talking about congressional oversight, we can't control what Congress does. I guess Bob can control it. I can't control it.
I don't think he can either.
We can control what the Department of Justice does. They should enforce their statutes. They have carefully, deliberately earned a bad reputation for enforcing the law neutrally. That needs to change.
Adam, Bob?
You want to go first? Yeah, and I will put a +1 on the importance of NVRA. I think that, to me, you know, this is a statute that, when it was hammered out and passed in '93, contains elements that, as you might expect, both sides like. access and integrity. The main places where this works are Section 5, the key motor voter part, where basically anyone who's going into a motor vehicle agency and is eligible and should be registered to vote at that point in time if they want to. And Section 7, which does the same thing for social service agencies that are run by the state, along the same lines as the DMV requirements. And then Section 8, which is the matching provisions. To me, we did see an increase in litigation in Section 5 during the previous 8 years, in that there were cases that were both proposed and then settled without litigation in both Alabama and Connecticut, two very different states led by very different leaders that both saw the evidence and said, yeah, DMVs, we have 88 to 91% of the population are going through and getting driver's licenses or state ID cards at the DMVs. It makes total sense that we do registration at that point. And not only do you do it when you move into a state, when you move inside the state, there are state requirements that is the place that you go and show up to the state and say, I've moved from one part of the county to the other, I'm changing my driver's license, and it makes sense to change my voting registration. So, because people, unlike us, don't think about voter registration and voting all the time. And so trying to make it easier for the general public that is a little bit more mobile now is important. I do think that appropriate list matching and Section 8 work probably could continue. I do think, and I do have questions as to whether or not it's targeted at jurisdictions or under the state. I mean, I think there have been a couple of cases that I've seen, and I haven't followed this decently, where a particular city or county has been focused on for a Section 8 case. And to me, if there's problems within the list, it's a statewide registration list. Let's look at the entire state. I do think that the NVRA is an important statute. All three major areas should be looked at and enforced when there's a problem in blue, purple, and red states. And so that's one piece I would say. I would say, and again, we don't work on explicitly voting rights litigation at our organization. The one thing that did concern me related to the North Carolina findings of fact was the pendulum back and forth about how the final law in North Carolina was constructed. And maybe John or Bob, you can correct me if I'm wrong, but there had been requests from the legislature to get specific details on race-based elements and how communities of color handled early voting in different parts of the state in the past. And then the draft of the law was changed to basically negatively impact those communities of color. I'm not sure if that's right. That was, I believe, the finding of fact from the trial court judge, with, in quote, with surgical precision. And that's something that I think, we have the parties and the political dynamic and all of that, but if there's a finding of fact that says that communities of color were impacted and research was asked, and then bills were changed to impact those communities, that's something we all should be concerned about. And so please correct me if I'm wrong, if I framed that in the wrong way related to the trial court piece, but I just did want to raise that point.
With respect to some of the litigation going to the cases, I think the Supreme Court is encountering a difficult problem in that racial and partisan polarization are becoming one and the same. And it is difficult to ascribe it is difficult to differentiate between what is normally partisan, designing things for partisan advantage rather than designing things in an impermissible way under the Constitution where it racially affects things. But I also want to kind of touch back on one of the things that Congress is very well aware of, where there's talks of grand policies of driver's license being convenient for everyone, and remember, Congress is diffuse. The principles of federalism are baked into it. They each represent constituencies in a specific state. Texas does their IDs for a very specific reason, for a very specific way, because it works for there. But let's say in New York, it doesn't have early voting. Does that necessarily mean that you should adopt a national prescription that you have ID cards that have to be swiped, or you mandate early voting, I don't necessarily think so. I think you could actually create problems of one of the things that members of Congress are uniquely aware of and makes it difficult working on these issues for Congress is they all want their election to work. And there's a lot of caution about breaking things that work. I know there were a lot of discussions about the Department of Homeland Security going in and trying to help each of the states. But elections in this country are naturally diffuse. Each of the states and we have localities running their own elections, and a uniform rule might not necessarily work.
Thank you. We'll take questions from the audience, but I'll start with one to get us going here. I'm
sorry, I was thinking about what you said. Just a quick comment. I thought the trial court found for the defendants on all counts, including intent. I thought that was an appellate court finding on intent.
I wasn't deeply involved in that, so
Okay.
but I just wanted, I didn't know whether John Tanner or you had gone deep in that. So please correct me if I'm wrong as far as the framing.
Consult.
The issue I think was in the papers, so we can take a look at that.
Great. So back to election administration. One question I had is talking about voting machines and those issues. Do the panelists think going forward that high-tech solutions are a good idea or whether low-tech is the way to go? And the related question is, when we're debating election administration and Congress's role, at the end of the day, how much of it just comes down to money? So as I understand some of the findings on why there are long lines, early voting has not solved that problem in many states. I have some experience litigating in Florida on this issue because voters tend to want to go on the same days, even for early voting. And so the bigger issue tends to be the number of machines and the number of precincts and spreading people out. And that's where real money shows up because you need to double and triple your staff if you're going to have more precincts, and you're going to have to pay for more machines. And so at the end of the day, low tech, high tech, and how much of this is wrapped up in money?
Well, we may have to endure some colossal failure to determine the extent to which high tech is, that like having the Russians choose our president or something like that to experience that. I know that there are some low tech solutions that commend themselves. Governor McAuliffe in Virginia just vetoed a bill that would have required the importation of your driver's license picture onto the poll book. The poll workers would have been admonished to consider that picture in priority over any other ID that you presented. And this was the picture, presumably, that you presented when you registered to vote at the Driver's License Bureau. I don't know why you vetoed that bill. But I think, that was one solution I thought made a lot of sense.
John?
Yeah, I've actually monitored well over 100, maybe 200 elections on the ground. And the one observation is that the optical scan machines, where you mark a paper ballot and feed it in, are much, much faster, and I believe they're much, much cheaper than the the DREs, the touch screens and so forth. And they also are much friendlier for older people, the older, or people who don't regularly work with computers, which is mainly older people. They are very important for people with disabilities, and it's just a very heartening thing that there is a machine available for people who cannot see or whatever, and they get to vote independently for the first time. That's wonderful. But I think the cost and speed factor of the optical scan machines is a big, big plus. One place I think that technology really offers opportunity is in voter registration. Right now we have a 19th century voter registration system where people fill out a piece of paper, usually with the help of someone who doesn't know how to help them. They're incomplete, they're illegible, and so forth, and then they get sent to someone who does data entry, and they operate with all the efficiency we expect of the Department of Motor Vehicles or other agencies. And it's a Rube Goldberg device, and by far the biggest thing that slows down voting and the biggest problem in elections is the registration system. There are just so many errors on it. And it should be possible to just automatically register everyone who gets a driver's license, everyone who goes to one of the a SNAP office or other a disability services agency, all of the NVRA agencies, and that's your voter list. And if there are some hermits out there who never interact with a driver's license office or other state agency, you can think broadly about what agencies to include and just put them on the list. And if you like, you can, with all the money you save, getting rid of all the underbrush that is our voter registration system, you can give everyone an ID, a picture ID, which would come in handy in their daily lives. The good thing about giving people, registering people at those sites is they make sure you are who you say you are. There is absolute integrity to those. People don't give you a driver's license unless you are who you can satisfy them. They don't send you checks unless just because you ask for them. You correct me if I'm wrong. And so you can, with great financial savings, create a voter list using 21st century methods or late 20th century methods rather than 19th century methods. Save a lot of money, have accurate lists, have integrity, and save some money.
No, go for it.
So I guess I'll start with the second question first. There's a lot of things that are about money. I think if you look at the HAVA's, payments to the states, there are many people who call it TARP for elections, and it's more of a historical anomaly to expect large amounts from the federal government to go to the states, but for elections equipment. That being said, state and local governments should make appropriate investments in these technologies because it's something that they have to do. The Constitution impels that you have these elections. The high tech versus low tech of I think states are starting to vote with their feet. Paper ballots do have the advantage of fewer points of failure necessarily and greater ease in auditing. I think after this past election, people have placed more importance on auditing an election in case you end up in litigation or a recount and determining what happened. And if you have a direct record electronic machine without necessarily a paper trail, well, you take out the memory card, you put it back in, and you're done. And there's not a lot of public confidence in the electoral process that's created by that.
This is something where I think you find agreement on folks on the right and the left and disagreement within different folks on the side. I generally think that there are interesting opportunities with more high-tech systems, but I totally think that there should be auditable paper-based backups or ability of folks to sort of make sure that they voted for the person that they intended to cast the ballot for. And so I think Bob frames it out in probably the right way. But I also think that we need to maintain that promise of independent, accessible voting for voters with disabilities of the one per voter polling place requirement of the Help America Vote Act. On the security question, and it's tied into the dollars, states and localities got to run their elections, and that makes total sense. There certainly was a lot of concern about DHS engaging or not engaging with providing guidance to the states on how to secure their state registration systems or other types of systems. Where I'm concerned about, and I understand the federalism argument there, but I don't know, and I haven't talked to anybody that does know with certainty that either all of the secretaries of state can completely 100% secure their system or say that they have cutting-edge technology to make sure that they can rebuff potential attacks to the system. or B, whether a small county in Ohio can stand up to potential hackers from a malicious government that is well-funded, resourced, and intent on maybe not even switching votes, but disrupting a system on election day that causes distrust in our faith in the process. And so my interest in the question, whether it comes from federal government or elsewhere, how do we make sure that the states are doing what they need to make sure that they're securing their system and they're able to rebuff any attacks or potential intrusions into the system? On the question of early voting and line wait time issues, I think we have seen an increase, especially in the West, driven by Western states, of increased use of vote by mail and early voting. I do think one of the interesting things about this is that in some places, it does take the pressure off bad management on election day, because if you have people that are voting early, they're not going to show up and add on to that potentially already long line. And so if you bank those folks that are going to vote anyways, get them out of the system, and then administer a good, strong election on election day itself, you're less likely to have problems. And we have seen an increase in use of no excuse absentee voting and early voting, I think, in different parts of the country. I think there are some, with the use of technology and data, there are better ways of fixing the line question. I've, within the last couple of years, become enamored with queuing theory. What the heck is queuing theory? It's what the folks that work behind the scenes at Starbucks and Jiffy Lube get into when they say, all right, so we have customers that come in and wait in line with their cars. You know, the quicker we can move them through the line, the more profit we will have, the less folks that leave the line and don't buy our stuff. And some of that can be applied to voting. And in fact, you know, Charles Stewart from MIT, who worked on the Bauer-Ginsburg piece, pulled together with some MIT queuing theory experts on, you have X number of voters per polling place, Y number of poll workers, Z number of voting machines. You can plot out generally how long the wait times are at different ports and time of the day using historical data. And what does that mean? You have advanced knowledge so that you can go to your county board or the state board and say, you give me one more voting machine per polling place or 2 more poll workers, we'll be able to get those line wait times down. So using management science, thinking through this in a meaningful way, I think it is a no-brainer and gives more power to the local election official to properly project where there will be problems in the future.
Thanks. Questions? Roger.
Thanks very much, Will. I'm Roger Clegg with the Center for Equal Opportunity, and a couple of the panelists mentioned Section 203 of the Voting Rights Act, and I wanted to ask whether Section 203 really is a part of the statute that makes sense as a matter of policy, and also whether it's constitutional. Section 203, among other things, requires certain jurisdictions to print ballots in foreign languages. And there are, as a policy matter, just briefly, some objections to that. Most people, would ask, well, gee, in order to vote, you have to be a citizen, and in order to be a naturalized citizen, you need to be able to speak English. So why are we printing ballots in foreign languages? Isn't that going to facilitate voter fraud? Isn't it expensive? And doesn't it create a disincentive for people to learn English, which is really something that we want American citizens to know? In addition, there are constitutional problems with that because, what authority is Congress invoking in order to require ballots to be printed in foreign languages unless there is some claim that not printing ballots in foreign languages is deliberate ethnic discrimination, which seems unlikely. I mean, the reason that ballots are printed in English is because it's cheaper and most people speak English. And again, there are these policy problems that arise if you print ballots in foreign languages. So should we have Section 203?
I'll take that. I think we definitely should. There are a lot of misconceptions about language ability within the United States. There are, first of all, people from Puerto Rico were citizens of the United States by statute, and they are taught in Spanish in their school by statute. And, that is part of it, but there are many other people Spanish speakers. I think the last time I looked, and I'm probably off a little bit on that, there were over 4 million people who were citizens of the United States who did not speak English well enough to participate in the electoral process, and who were Spanish speaking. There are also many people who speak other languages. There are many Native Americans who are born here, of course, who did not go through immigration, of course, and who do not speak English well enough to participate in the electoral process. A large percentage of them, I think, is about a third in some of the counties that I sued during my Justice Department days. The reaction of the people who were able to vote is wonderful. You have people going into a polling place and seeing someone who can translate the ballot for them and leave saying, this is the greatest country in the world. And it is. And, you know, the people who don't speak English very well usually are older people, and their children and their grandchildren are in our armed forces. And I think they should be able to vote.
I mean, it's an interesting question in a couple of ways. You know, I monitored polling places, among other things, for John Tanner, and the one that I remember is Mary Queen of Vietnam polling place in New Orleans. And you know, you feel that there are definitely people who are American citizens, and it's, you know, there's no illegitimacy there, but they don't speak the language well enough to navigate all of the ballot questions and all of the, you know, detailed issues, although they do speak English.
There are a lot of English speakers that have problems with that.
There are, but you know, the constitutional question is interesting and unsettled and untried. You know, the question is, you know, no abridgment of the right to vote on account of race or color. Does that include ethnicity? If it doesn't, is that interpretation by Congress congruent and proportional under City of Bernie to what's required? If not, I mean, where else is that enumerated? And
I should say that, you know, we testified against the reauthorization of Section 203 and made exactly that point, that it's very difficult, I think, to argue that it's congruent and proportional. And of course, you know, you could make a special exception for Puerto Rico and for American Indians. Those are, you know, unique circumstances. But I think for others to, you know, to assert that not having languages or not having ballots printed in foreign languages is deliberate ethnic discrimination is quite a stretch.
Well, there's a history of deliberate exclusion of Spanish speakers from voting. The particular groups are under the broad interpretation of race or color at the time of the adoption of the 14th Amendment. You know, the original intent was to cover a lot of groups that we no longer think of as racial groups. Of course, the specific languages are tied to Asia, to the Native Americans, who are distinct racial groups, and many people, and certainly in the original intent of the 14th Amendment, many other groups would have qualified, including Latinos who have racial characteristics. I'd also say that the relief in the statute is very narrowly tailored. The persons who have access, a right to access to the information, are people who are citizens of the United States, who are over 18 years old, and who cannot participate in the elections in English. It's not the broader, you know, this applies to all Chinese people or all black people or whatever. And so you know, the Congress is satisfied. No one's been able to do anything in the court. So getting back to the oversight issue, certainly this administration should be vigorous in enforcing a statute that protects the core right of Americans.
Thank you. Thanks, Bob. Maybe this would be a good lawsuit.
Will, great panel. Thank you for convening the gentleman here. Dan Callahan is my name, from the Government Blockchain Association. So blockchain is that Web 3.0 technology that secures cryptocurrencies. And while not perfect, they are secure at the level of NSA encryption. And the faults in some recent cryptocurrency faults have been not related to the technology itself, it seems to me. But we advocate for the use of these technologies in unique governmental processes. So my question is, what advice would you give to a nonprofit association who advocates for advanced technology for these very complex problems, certainly not as a panacea solution, an all-encompassing solution, but maybe a phased-in solution? Adam, you and I should follow up regarding that federal agency idea, because maybe technology can help get to some of those broad parts of the culture here in the United States that use smartphones to do just about everything. It's being done in Estonia, by the way. So I'm asking for advice to the nonprofit association here in town that advocates for use of technology.
I think there's some interesting things being done with blockchain and those sort of vanguard elements of technology. I think that because of the challenges that occurred with potential intrusions into the statewide registration lists, that the general ethic that I am hearing from the community is a little bit more nervous about new technology into the system. But to me, I think we all, private industry, government, nonprofit industry, should be exploring different innovations in voting, as well as how to secure it and make sure it's verifiable. But I think after the last election, there are some greater concerns about newer technology.
Hi, Carrie Dever from the Center for Corporate Integrity. I actually focus on two areas. One is Wall Street crime. The second is intellectual property, IDIP. The gentlemen that put the structure together back in the 1960s have said since then there is no security. Why we're not getting that message, I don't know. But I want to discuss felons. I have not heard that word raised in terms of voting rights. Judicial Watch sued the state of Virginia. I, a couple of days later, walked the state of Virginia through documents I have that gave them the basis upon which they were stored. I think to date it's 156,000, which usually gets like a wow factor when I share that I provided that way forward. I want to understand more about felons and voting rights. I showed that there are the SROs that don't report crimes to cops, and I built a crime lab. I'm very for crimes being reported to cops. So the Madoff 50 years ago had no fingerprints done, no incarceration, no mugshot, none of that. And these young men and women and older, Democrats and conservatives that go to jail, come out known as felons. They can't get their crimes expunged. So I'd like to address felons. I'll leave that open to all of you. But the fact is, Virginia gave people back the rights, and those people actually are still walking around with a taint. They may be able to vote. One man said, I can't name my child after me because I can't get my crimes expunged. So we have that. I'll leave it open-ended, please.
Thank you. Well, Judicial Watch sued because the Virginia Constitution forbade what the governor did. And in fact, the Virginia Supreme Court ultimately ruled in a previous case brought prior to ours, directly to the Supreme Court. They ruled that that was in fact the case, that you couldn't have a blanket pardon of the type attempted by the governor. But that's a state-by-state issue. What will get you barred in one state won't work in the next.
Just to finish off a point, yes, and Wall Streeters are granted their licenses on a state-by-state also. So on that comparative, you have people that don't go to jail and stay out voting and then have fines paid into the Treasury, not reimbursing the victims, and people that paid their debt to society come out, sometimes restoring what was taken to victims, but not being able to vote. There's something in there I think both sides can come together on, looking at the facts as I've been bringing them out slowly, carefully through FOIAs and documents.
Thank you.
Hi. I'm from Montgomery County, Maryland, and last November I volunteered to help assist in a polling place. So I'm curious about the sort of high technology you were discussing, because in my experience at the polling place, the biggest bottleneck wasn't necessarily at registration or voting. It was at the table where they give out the ballots and explaining to people how to use them, because people seem to get very confused about how to vote and how the process work. So I'm wondering what sort of technologies you were discussing to streamline the process.
I can jump. I mean, to me, this is something, when we're talking about improved quality of election administration in the United States, you know, for a long time, the local clerks were in a silo and they did things the way their predecessor did. I actually think that because of, you know, Bush v. Gore was good or bad, depending on your perspective, it prompted a lot of conversation both within folks across each state and between folks in different states. And one of our grantees, the Center for Civic Design, really pushes out a lot of model ways that you can promote education for voters and for poll workers on how to make the voting process easier. Step one, you know, you get the ballot. Step two, you do this. Step three, you're done. And I mean, a lot of this, you know, takes from lessons from corporate America, and as to, you're dealing with a whole bunch of folks. You have 100 million plus people doing one thing, all sorts of different levels of educational background, experience. How do you show that and graphically in a way that everyone, no matter where they come from, can sort of work their way through the process? The smart folks are both creating new ways of making it easier for both the election workers as well as the voters, but we certainly need to increase the communication between jurisdictions as to the best practices. This is a practice issue, I think, not necessarily a policy issue.
Well, I would add that the social science isn't settled, so people are talking about what might be a good idea, and sometimes there's not a lot to back it. And I would refer to, Mr. Ambrogi referred to Charles Stewart. He appeared as an expert for the plaintiffs in North Carolina, and he had predicted, based on his analysis of queuing theory, that minority turnout would crash. I mean, not just go down, but absolutely crater. And it went up. So, figuring that the social science isn't subtle.
Did it go up as an absolute or as a percentage?
It went up as an absolute, as a percentage. It went up, registrations went up, turnout went up, and absolute numbers went up.
I'd like to commend you for working in the polls. One of the problems, especially with new technology, is that nationally the average poll worker is 72 years old. So for everyone who's, for every poll worker who is 18, there's another who's 126 years old. And, it's just great to have someone around who's comfortable with the technology. Anytime a new technology is introduced into the polling place, it takes about 3 elections before anyone knows how to work with it. And then things start to get smoothed out. But doing something new, especially something with complex technology, is fraught.
I have a second question. In Maryland, they do provisional voting where somebody isn't necessarily registered or able to vote. They can still cast a ballot, and then later it would be looked over and vetted. I'm wondering what your thoughts on that process is.
That's actually part of the Help America Vote Act. So it was an introduction by Congress, and one of the things they got right.
I have a quick question for Adam in light of what Robert says. The left talks about being for list maintenance, but it seems like every time it happens, they fight it. I'll just give you 2 examples. At the same time, Bauer's presidential commission with Ginsburg came out for cleaning up the voter rolls. His law firm was suing Virginia. And they nominated Myrna Perez, the EAC, who at Brennan Center declared all list maintenance list purging. So how do we get the left? Is there any way they'll actually go along with some list maintenance? And as Mr. Popper said, they did none of it in 8 years in the Obama administration.
Sure, and obviously you don't speak for Mr. Bauer or Ms. Perez. I think Pew looked at this issue and they brought in some of the brightest minds from Microsoft and tech firms to try to figure out how to balance the access and integrity piece that we've all been struggling with. And to me, that solution is the list matching combination of ERIC. This is a system that Pew created but then turned over to the states, is run by member states, and it's very carefully balanced of red, blue, and purple. You have Utah and you have Delaware as members of this system. And what they do is they really, use a confidential and effective algorithm to compare folks that are participating in the system and make sure that they're not registered in more than one state. And at the same time, it looks at the driver's license lists and identifies those folks that are eligible under state records, and does the first a one-time outreach to those folks that are potentially eligible but unregistered, and ask whether they want to register to vote via a mail form. It is a combination that folks on the right and the left have agreed on as a way to combine the concerns that we all have. And I do think that we should be looking, in times like this, we should be looking for, and especially related to political reform, because obviously no one wants to be, picking on policies that just impact what they see as helping their side or hurting the other side. We should try to figure out those ways that are agreed on as rising tide lifting all ships. I think the ERIC option is the best way to go. I'm sad that Florida did not pass it through, but I think there's going to be some interesting successes in red states this year, because it really does provide a check on both the integrity of elections as well as promote access.
Well, if I could add another question about the social science not being settled, but the Pew ERIC system is not federal law. The NVRA is. And, as said, it was a compromise. The idea was that if you're going to increase ballot access, you need to increase election integrity. And to have an administration that doesn't enforce one part of the statute and then joins in lawsuits to shrink it is not helpful.
Hello, Andrew Brown from Raleigh, North Carolina. So one of the hotbeds of litigation, and have had some experience in some of the challenges to redistricting and whatnot there. And I'm interested in some of the prognosis for the future about, I think it was referenced earlier that perhaps one of the ways that the VRA is outdated, in the sense that the way that race and political affiliation often correspond to maybe a higher degree than they did at one point. And going forward, with the Shelby County decision, what are some of the prognoses as to how, certain parties can politically advantage themselves? It seems like either party can make an argument either way based on the facts and the state standards, because of the way the race often corresponds with party affiliation these days. So any thoughts on that going forward?
Well, it's a difficult issue in the law. It's a difficult issue constitutionally. You can't have a pretext for race. At the same time, there is a practical concurrence, racially in terms of political partisanship. The Arlington Heights standard and the standards that we use, I don't think address it adequately. I don't know how you would write a Supreme Court decision or a constitutional amendment that did. The racial discrimination existed, and in ways that have been appalling and can be appalling, and you need to address that. But at the same time, to take what is a political maneuver and to always assert that political maneuver is racially based because it has a racial effect is wrong. And perhaps the best way to do it in the law is with some sort of causation analysis, and some very serious consideration of effects. And now I'm getting into the weeds of some decisions that I'm thinking about, but that is a tough issue.
Well, thank you all for joining us today. Thank you to our panelists for a great conversation on what I thought was a great and timely topic, and we appreciate everyone taking the time to be here.